on mute and also wait until the presentations are complete before typing any questions you might have into the chat. So now, without further ado, Rachel, please go ahead, and apologies for making you go first.
No, my pleasure. Thank you for the introduction, and also thank you to the Academic Engagement Network and everyone who took time to join us today for this webinar. I'm going to take a moment to share my screen, and I hope everybody can see the slides now. So I wanted to talk today about the end of affirmative action and the future of Jewish inclusion at America's colleges and universities. And I want to really focus on three different points. One is just the cases themselves that Rafa mentioned, the two decisions that the Supreme Court will be handing down in all likelihood in June of this year, addressing affirmative action at Harvard and the University of North Carolina. Then I want to turn to the Jewish voices in the litigation, the way in which Jewish organizations have presented very different views on the issues before the court. And finally, to conclude with some thoughts on the likely impact of the cases on Jewish students at college campuses. So let me just start with the decisions themselves. As I mentioned, the court has two companion cases, one involving an elite private institution, Harvard, the other involving the University of North Carolina, both of which use voluntary affirmative action. They haven't been found guilty of past discrimination, so they're voluntarily using race in admissions to diversify the student body. At stake in these cases is a framework for addressing affirmative action in higher education that first was developed in Bakke, Regents of the University of California versus Bakke in 1978. That framework has been in place, as you can tell, for decades and not without challenge. The court has revisited the constitutionality of affirmative action repeatedly. In 2003, in the Grutter and Gratz cases involving the University of Michigan, and again in 2014 and 16 in the Fisher case, which challenged affirmative action at the University of Texas. Now, the Bakke framework is interesting because it really rests on both the First Amendment and the 14th Amendment. The First Amendment protects our liberty interests in speech and expression. And the court said that institutions of higher education are really unique because they have academic freedom. And that freedom includes institutional autonomy, not just my right to speak as a professor, but the institution's right to operate autonomously to achieve its goals, including the composition of the student body. So the court said we have some deference to institutions of higher education and this liberty interest that they have. But because they're using race, we still need to apply strict scrutiny under the 14th Amendment, the Equal Protection Clause, because race is a suspect classification. So even if we think universities have a compelling interest in diversity, any use of race has to be narrowly tailored. You have to be absolutely sure that you need race to accomplish your goals. And that left some unanswered questions about when race-neutral alternatives might be a viable option, which means that you no longer need to use race in admissions. So the Students for Fair Admission, which brought both of these cases, had a litigation strategy. It sued Harvard and North Carolina at about the same time because it wanted both a public and a private case to be in the federal courts. Now, the ultimate end game was to have the Supreme Court hear these two cases together. That almost got derailed because the Harvard case moved expeditiously through the federal courts in the First Circuit. And so there was the district court decision, the Court of Appeals decision, and then the court granted certiorari to review the case. Meanwhile, in North Carolina, the case was languishing in the district court. It was very slow. And so the court ultimately, when the district court in North Carolina handed down its decision, expedited review, said we'll skip the Court of Appeals and just go straight to the Supreme Court because the court also wanted to hear them together. Now, why is it so important that these be companion cases? I think one critical point is that the court wanted to address the distinction between public and private institutions of higher education. When you remember that brief history that I gave you, every defendant in these prior cases was a public flagship university: the University of California, the University of Michigan, the University of Texas. This is the first time that the court has heard a challenge to voluntary affirmative action programs at an elite private institution. And it's not just any old elite private institution, it's Harvard. And Harvard's plan for admissions was the very one that Justice Powell in the Bakke decision held up as the model for how to do affirmative action. So one question is, will the court extend its framework to private schools like Harvard? The likely answer is yes, because Harvard receives federal money, and so it's subject to Title VI of the Civil Rights Act of 1964. Title VI is a non-discrimination statute, and the court has previously said that that non-discrimination provision in Title VI is coextensive with the Equal Protection Clause. So it looks like the court will extend this to Harvard and say, so long as you take federal monies, you're bound by Title VI, which essentially subjects you to the same requirements as a public flagship would face under equal protection. By taking the cases together, the court has ensured that whatever decision it reaches will affect every institution of higher education in the United States, every public flagship school, every selective school, and for private schools, any selective school that takes federal money, which is basically all of them. So the court has to consider a couple of very important issues. One is whether diversity is still a compelling interest. And that, if the court says diversity is not a compelling interest, then we are going to see that that's the end of voluntary affirmative action everywhere, unless the only situation in which you could use race and admissions would be to remedy past discrimination, and that's not voluntary, that's subject to court mandate. But we really don't have institutions that have recently been found guilty of intentional discrimination. So it would effectively end affirmative action. The other possibility is the court could say the programs were not narrowly tailored because they use race too much, or they don't have an end date, or in the particular case of Harvard, because there was reverse discrimination against Asian Americans. So I wanted to dig a little deeper into those two rationales, just so you understand how the court is thinking about them. I took a look at the oral arguments in the cases, and one of the things was several justices asked about the language and history of the 14th Amendment, the Equal Protection Clause. And if you look back at the Bakke decision, Justice Powell was a very pragmatic jurist. He didn't really adopt textualism and formalism. He thought about the current context, contemporary demands. And so for some justices, that's just anathema. They feel we should be bound by the language and history. And they asked very specifically about the 14th Amendment to clarify that it only had a remedial objective, to correct the vestiges of slavery. And therefore, it didn't really support other rationales like diversity. So if some of these justices endorse this view, they would likely say that diversity is not a compelling interest, only remedying past discrimination counts. The other area, and it's interesting because if you go and actually read the oral argument, you'll see that most of the questions are directed at narrow tailoring. And the court focused on the reverse discrimination against Asian Americans at Harvard. So there was quite a bit of discussion of whether or not these applicants who had the highest profile in terms of grades and standardized test scores were being discriminated against, because if you looked only at their academic credentials, they would make up 43% of the class at Harvard, according to Harvard's own internal studies. And so that was one big issue. But what was interesting to me was also the emphasis on whether both Harvard and North Carolina had exhausted the race-neutral alternatives. And there were very specific questions about getting rid of preferences for alumni, donors, children of faculty and athletes, using socioeconomic status, and so on. And then a lot of questions about what Justice Sandra Day O'Connor said in one of the Michigan cases in 2003, that she hoped that in 25 years, we wouldn't need to use race anymore. And do the math, 25 plus 2003 is 2028. So it's pretty close. But a lot of the justices wanted to know if Harvard or North Carolina had some termination point in mind, some end date when this would be over, and whether they thought that by 2028 they could do away with the use of race in admissions. So now I wanted to get to some of the immediate aftermath in general. If the court decides that diversity is not a compelling interest, it will be gone. You'll have to show past discrimination. But if they use narrow tailoring a lot, and they're aggressive about narrow tailoring, then I think a lot of colleges and universities are going to be worried about whether they're going to be sued because they've made an excessive use of race in admissions. And this will probably, regardless of the rationale, force them to look very carefully at race-neutral alternatives. It's very possible that the court will be fragmented with a plurality, less than a majority, supporting the claim that diversity is not compelling, and another group saying that it is compelling, but these aren't narrowly tailored, and a few justices saying that the programs are acceptable. So we will probably see fragmentation. We've seen it in the past cases. We're likely to see it in this one. And that leads me to one other point that I want to make just about the background of the doctrine. And that is, throughout the colloquy during oral argument, people assumed that race-neutral alternatives would be a safe harbor, but it's not clear that they will be, because the Pacific Legal Foundation, which filed an amicus brief in the cases, has already sued selective high schools and magnet schools, saying that they changed their admissions criteria, which were facially neutral. They didn't mention race at all, but they, for example, got rid of standardized test scores or lowered the weight for those scores, or adopted percentage plans for the schools in the area. And they said these are all race neutral, but their purpose is to promote diversity, racial representation, and they're still unconstitutional because they have an illicit racial motivation. So you should plan to see more litigation on that issue as well. Now I wanted to turn to the second area, which is Jewish voices in the litigation. And there have been briefs filed, amicus briefs filed by Jewish organizations. And one of the things you see is the kind of internal heterogeneity of the views, because they span the entire spectrum. So you have the Brandeis Center, and it filed a brief in support of students for fair admission, challenging the legitimacy of voluntary affirmative action. You have the Jewish Coalition for Religious Liberty, which said, we're not taking sides, we're neutral, but we're worried that you don't give enough weight to religious diversity when you make admissions decisions. And the Anti-Defamation League, which filed a brief in support of Harvard and North Carolina, saying these programs are valid and should be upheld. Now, I thought it might be helpful for you to just see a little of the language in the briefs. The one that got the most attention was definitely the Brandeis Center brief. It got a lot of publicity because it echoed a claim that Students for Fair Admissions had made, which is that the reverse discrimination against Asian Americans is basically just a new version of the past Jewish quotas in the 1920s and 1930s. Now, this brief did make an impression on the justices. In oral argument, they asked explicitly about Jewish quotas. And indeed, they went even a little further, I think, than the Brandeis Center, which was, they said, did Justice Powell get duped? Harvard didn't tell him that they had this history of Jewish quotas that tainted the admissions program. And the response by the attorney representing Harvard, Seth Waxman, was no, that wasn't duplicitous because any vestiges of the Jewish quotas had been eliminated by the time they were doing an affirmative action in the 1970s. The Jewish Coalition of Religious Liberty made clear that while when you apply to Harvard, you can put down your religion, it's redacted when it goes to the review committees. And they felt that if you're going to embrace diversity, you ought to include religious diversity, and it wasn't appropriate to redact the religious affiliation of applicants. And what's so interesting there is the justices did ask about this. And Harvard's response was, we get plenty of religious diversity with the redacted form, so we don't include it in the admissions information for the reviewers. Now, the Anti-Defamation League also weighed in and basically rejected the Brandeis Center's argument that the Jewish quotas had tainted Harvard's admissions program and made its contemporary program unconstitutional. And so you really see the full spectrum here. But I think that these issues that were raised in these briefs did get the court's attention. So they were discussed in oral argument. Now, let me get to what's probably of greatest interest to all of you, and that is the implications for Jewish students. Now, in the wake of these decisions, and I think that, you know, the widespread consensus is that the court is going to curtail significantly the use of race in admissions, is that offices of diversity, equity, and inclusion will likely be preoccupied with figuring out how to comply with whatever the court says. And so they will be mostly concerned with, can we still use any race conscious admissions? If we can't, what sort of race neutral alternatives do we have available? And therefore, I think any other group is not going to be getting a huge amount of attention from these offices. In addition, these offices are in some cases facing challenges to their very survival on campus. The Chronicle of Higher Education has a legislative tracking function, and 26 bills have been introduced to eliminate DEI offices. They are in 13 states where these bills are still alive. 2 were tabled or failed, but they're in some fairly large states in the South, in the Midwest, and then a couple in the West. There's none in the Northeast at this point. Now, I don't think Jewish students have been a terribly high priority for DEI offices more generally, but with these decisions, I think the likelihood that they'll get a priority is even lower. And I think that what that means is the campus climate for Jewish students isn't going to be a preoccupation for DEI offices in the wake of these decisions. That said, however, there's still non-discrimination principles that apply. So I would expect DEI offices to get involved when there are things like hate crimes or harassment that target Jewish students. And I wanted to give you, examples, Hillel offices that have been defaced. More recently at Stanford, there was a Jewish student in the dorm. There was a whiteboard across from the dorm, and repeatedly someone has put swastikas on the whiteboard and images of Adolf Hitler. And so those kinds of behaviors, which involve either hate crime or harassment based on Jewish identity, I think those will still get attention, but they're pretty reactive, and they don't necessarily address the climate and how to prevent those things from happening. I think that the other issue that will be important is that whether or not an action is discrimination or whether it's protected speech. And I'll give you a couple of examples so you can think about them after this webinar, but one of them involves a group called Groypers. The Groypers organized a college road trip after Kanye West, who goes by Ye now, announced that he was going to run for president in 2024. Ye has made some very high-profile anti-Semitic comments. And so the road trip's theme was, Ye is right, change my mind. And if you go and look at what happened during the road trip, they would set up, they would make their claims, and then they would also individually find students and try to engage them in a debate about Ye and his views and videotape it and post it online. Now, when people said this was inappropriate, Groypers argued that they had free speech rights to give the presentations. And they argued that the Anti-Defamation League, in challenging what they were doing, was engaged in impermissible censorship. It turns out the road trip is over for the moment for lack of funds, but this is an example of the debate over what is speech and what is discrimination. Another case study involves the University of California, Berkeley School of Law, where student organizations said that they would not invite speakers who support Zionism or Israel's policies. They also required that members support boycott, divestment, and sanctions movement and participate in training on the plight of the Palestinians. Now, there were alumni, faculty, and others who became concerned about this. And indeed, Berkeley's own magazine picked this up, and there was a monthly issue, and on the cover was a little Jewish free zones title. And the dean, Irwin Chemerinsky, defended the students and said that this was permissible, protected activity under the First Amendment. And so critical to the distinction that the dean made was discrimination based on viewpoint and discrimination based on religion. And he saw this as viewpoint discrimination, and he likened it to Jewish law students who didn't have to invite Holocaust deniers, or a law student Republican group that didn't have to invite socialists, or Black law students who didn't have to invite white supremacists. And so he distinguished between bylaws that were anti-Semitic and those that were critical of foreign policy, in particular, Israel's foreign policy. Nonetheless, the Office for Civil Rights has actually opened an inquiry into what happened at the law school at Berkeley. Now, there's another group that issued a report in 2022 questioning the binary approach that Dean Chemerinsky has taken, because according to this view, attempting to decouple Zionism from Judaism is itself an assault on Jewish identity. And so they argue that by forcing students to compartmentalize their Zionist beliefs, they actually undermine their Jewish identity. And so Jewish students will feel the need to hide their identity on campus, detach in part or in whole from Jewish life, and do what is sometimes called covering of their Jewish beliefs and commitments. So I think for all of you on this webinar, the questions that arise here are very different from the ones that will be the preoccupation of DEI offices. They'll be worried about whether something is race conscious or race neutral. But I think that when it comes to these issues about anti-Semitism and anti-Zionism, the question is, what is free speech and what is impermissible discrimination? And so I hope you'll think about how your own DEI office, if you have one, would handle this kind of issue, for example, with the student organizations. Would it treat this as protected speech, a viewpoint discrimination, or would it treat it as a form of anti-Semitism? Would you get involved at all in this kind of dispute? And if so, how might the Academic Engagement Network help you in that regard? My concluding thoughts are these. I do think DEI offices will not be hugely invested in issues affecting Jewish students in the immediate wake of the affirmative action decisions. As I mentioned, I think they'll be reactive rather than proactive. But I think, therefore, it's important to explore alternative ways of elevating consciousness about the Jewish experience, making it a more salient part of campus life. And I really believe that some kinds of exhibits, performances, student convenings, and other such events, which happen outside the scope of DEI offices, can be an important way to raise both the visibility and a kind of understanding of the Jewish experience. I wanted to give you an example, which is Americans in the Holocaust, which went on tour from the Holocaust Museum for the first time during 2021 to 2023. I'm happy to say one of its first stops was here at the University of California, Irvine. But that's just one example. And I do worry that it didn't get as much attention as it should have because it was sort of in the thick of the pandemic. But I think it's a wonderful example. And I think every campus has its own distinct opportunities to raise the visibility of Jewish life, culture, experience. And I hope that you will think about what the resources are on your campus and how the Academic Engagement Network can facilitate your being an advocate in this regard. And so I want to thank you for your time. And now I'll turn it back over to my co-presenter.
Rachel, thank you so much for your analysis and for raising these excellent questions. AEN and our faculty and the administrators we work with will absolutely be grappling with the questions you raised on an intellectual and practical level. So now I want to turn it over to David. Thanks for joining us.
Thank you. Thank you so much for having me. I think it worked out well that I had trouble getting on because Rachel gave a wonderful overview of the case, which I wasn't actually going to go into such detail about. So that's great. I could skip over some of my a little bit of my introductory material. And also I want to apologize. We have like a leak in our ceiling above me, a pipe in our house, and it's like we're having some emergency repair. So there's some banging in the background. I apologize for that, but otherwise our ceiling will collapse. Anyway, so going right into the cases, since Rachel described them, my read of the oral arguments was that at least 7 justices, including Justice Kagan, all agree at a minimum that universities must seriously consider and to a significant extent exhaust non-racial alternatives to achieve diversity before using racial preferences, even if they were to agree that diversity is a compelling government interest. And Harvard in particular seemed to acknowledge in oral argument that eliminating alumni preferences, athletic preferences, employee preferences would increase diversity. And it seems like the same level of diversity would be achievable with those changes, while Harvard's the scores of the students would go down from 99th percentile to 98th. And Harvard's basic argument was, well, we're Harvard. Why should we have to do that? We want to keep that stuff, and we want to pursue affirmative action. I don't think that was overly persuasive. And I think if we still had a somewhat more moderate court with O'Connor and Kennedy as the swing votes, I can imagine a narrow opinion saying that Harvard and UNC's admissions policies are illegal because, look, they've had since 1978 in Bakke to explore race-neutral alternatives, and they really haven't done so in a serious way. But I don't really expect such a narrow opinion because, first of all, the court has grown more conservative. And second, I think the conservatives gave the clear impression that they think defendants in similarly situated schools have been openly cheating. Ever since Bakke, the court keeps saying, yes, we're going to let you use affirmative action, but you really have to be careful about it and do it in this narrow way. And universities keep acting as if the court has told them they can do whatever they want as long as they're not using hard quotas. And I don't think, unlike Justice O'Connor in 2003 and Grutter or Justice Powell in 1978, that the current majority trusts universities to obey any sort of rule short of not being allowed to use race at all. And it doesn't help really that conservative justices are basically persona non grata elite university these days. Justice Kavanaugh, for example, used to teach at Harvard Law School until the allegations of sexual assault were leveled against him, and Harvard felt pressure to basically relieve him of those responsibilities. He's actually teaching at my law school now, and he lost that gig. But my basic point there is that at one time, the elite of the legal world, whether they were Republicans or Democrats, conservatives or liberals, would have had warm, friendly ties and feelings about elite universities, such as that they didn't really want to interfere with them too much. I think now it's, if anything, it's the opposite, that the justices are more likely to resent these places. They also might resent, Rachel started off by talking about how the affirmative action in university cases really sounded in academic freedom as much as anything. And I think if the establishment had stuck to that, they'd be on better ground. But just for example, my law school, we had a situation 20 years ago where the American Bar Association came and ordered us to admit more minority students at very short notice, without regard to whether these students were likely to succeed or not. And my point there is that this wasn't an actually academic freedom choice of my law school. We didn't have a faculty vote. We didn't have faculty discussions. We had an outside accrediting agency that is charged with the government with accrediting us, telling us what we had to do. And so it's not really anymore a choice if you're a university whether you want to use these preference policies or not. It's an obligation. Relatedly, about the case itself, I thought there was a really odd strategy by both lawyers for both UNC and Harvard that denied that race is a dispositive factor in admission. And they kept going back and forth on it. It's not dispositive. We consider the whole applicant. But why do you ask about it if it's not dispositive? We ask about it because we need to know and consider it, but it's never dispositive. Well, it can't mathematically be the case that it's never dispositive, but if you tell us we can't use them, the number of minority students is going to plummet. So I don't think the court was buying that. Another interesting aspect of the oral argument was that the court in the past has basically just accepted the classifications that the universities use for diversity purposes, primarily African American and Hispanic, as a given. But this time the court expressed interest in whether the classifications that the universities use are really coherent and diversity enhancing. Justice Alito, for example, pushed UNC's lawyer on why it makes sense to even have an Asian American classification. He said, what do people from Afghanistan and the Philippines have in common that you should consider them part of the same classification? Justice Kavanaugh, meanwhile, asked UNC's attorney which box Middle Eastern Americans are supposed to check off. And I think what he was trying to raise the question of is, well, why do you not consider them to be diverse? Because Middle Eastern Americans are put into the white category on the Common App, which most colleges use, and some people would consider them to be people of color who would add to diversity. Remarkably, UNC's attorney claimed not to know the answer to that question. There is an obvious answer. If you look at the Common App, they ask if you're white, they ask if you're European white or Middle Eastern white. But in any event, I don't know if he was being honest that he didn't know and never thought about it, or he just didn't want to answer the question. But very interesting that the court was concerned with the internal coherence of the classifications. When we were at the stage of the Bakke case in 1978, most of the students admitted to the program in that case were actually Chicano or Asian American, but still the debate was almost entirely over whether affirmative action could be used to make up for discrimination against African Americans with slots that would have otherwise gone to white applicants. So there was a certain amount of cosmic justice, let's say, involved in allowing African Americans who had been discriminated against for centuries to get some advantage over whites who had been the discriminators and had privileges for that reason. But since then, the United States is dramatically more ethnically and racially diverse. 25% of the 18-year-old population is Hispanic now, compared to about 15% African American, and Hispanics are maybe 5% in the 70s. Asian Americans are about 7% compared to less than 1%. Even the African American category is increasingly problematic because 21% of African Americans are first or second generation immigrants. And plus you have increasing numbers of African American students who have one white parent. And if you look at the data that the universities collect, it turns out that at places like Harvard, the immigrant first and second generation immigrant and biracial applicants who check off African American are disproportionately getting the slots. Something like 2/3 of the slots at Harvard go to such students. And meanwhile, rather than the non-beneficiaries being white, Asian Americans are substantially so-called overrepresented at these universities. So to the extent they're taking slots away from people to give them to Hispanics and African Americans, they're mostly taking them away from Asians. Along the same lines, Justice Kavanaugh, interestingly, suggested a compromise that brings us back to pre-Bakke. So before Bakke, the primary rationale for affirmative action was to redress historical discrimination with present effects against African Americans, not diversity. So Justice Kavanaugh asked whether universities could implement a preference for descendants of American slaves as a non-racial classification, a political historical classification based on what happened to one's ancestors in the past, which would not include immigrants, would not include Hispanics, for example, and would not, because not a racial classification, be subject to strict scrutiny. The lawyers for SFFA said, no, that would still be a racial classification, but that's not at all clear to me that either that's correct, intellectually speaking, or whether the court would agree to that. In any event, my best guess is that the court is going to overrule Bakke and Grutter and hold that racial preferences can no longer be justified under a diversity rationale. So that's my general talk. With regard to the Jewish stake in this, Rachel gave you some aspects of that. I'm going to give you some others. First, to the extent that universities implicitly reserve spaces for Hispanic and Black Americans, given that there are relatively few Jews in those classifications, this winds up limiting the number of slots at elite universities that Jews can compete for. Partly, but not totally as a result of this, the percentage of Jews at Ivy League universities and other elite schools has plummeted. When I was in high school, it was 25, 30, 20. Now you're in the single digits at most of these schools. More generally, the push for diversity has been accompanied by a push to eliminate or downgrade standardized tests. Standardized tests were implemented by universities in part to prevent universities from using subjective criteria, which would allow them to just sort of maintain themselves as elite WASP, prep school bastions and let people like Jews and Catholics in. But now these tests are seen as barriers to other minority groups. And this is not really good for the Jews as such. Second, with diversity endorsed by the Supreme Court as a compelling interest that supersedes other potential constitutional limitations on the government, many universities, including in California, have taken to requiring prospective faculty to write diversity statements on their applications, explaining how they will work to achieve diversity, what they've done in the past to achieve diversity. I think there are serious First Amendment problems with these statements. They could be analogized to the non-communist oaths of the 1950s, but it goes beyond that for Jews, because it's not just that you're being asked to express fealty to a particular version of diversity. It's also the fact that when they talk about what are you going to accomplish with regard to diversity, they don't mean being a mentor at Hillel. They don't mean being active in the Jewish community. That's not ideologically what DEI is generally all about. And being Jewish or facing anti-Semitism, they don't care. One thing that's very helpful if you want to be able to show that you're going to add to diversity on campus, to be able to talk about it from your lived experience as a member of a racial minority group. Since, again, the vast majority of Jews in the United States are not members of racial minority groups, it makes it more difficult for Jews, whatever their ideology, to get positions at universities, and is bad for recruiting, being able to recruit Jewish faculty to universities. Third, this is not something people are allowed, in effect, to say out loud, but it's kind of obvious. When you decide to admit students with lower SAT or LSAT or MCAT scores, the reason you have those scores to begin with is that students who do better on those tests are more academically prepared to face the rigors of the school. As a result, the students who are admitted with lower scores tend to do worse, often substantially worse. In The Shape of the River by Derek Bach, like 20 years ago, I don't know what the stats are now, basically being African-American was worth about 250 to 300 points on your SAT as far as admissions goes. That's a very large gap. That's the difference between going to mediocre State U and Harvard, and your average student at mediocre State U is not going to do well at Harvard. So there's no reason to expect minority students with those scores are necessarily going to do well. So as you would expect, students admitted with lower credentials tend to do worse. But instead of just acknowledging that fact and trying to do whatever one can to make up for it, extra tutoring, more programming, pre-college programs, whatever it might be, universities instead declare, well, students of minority background are doing worse than white students. It must be because of oppressive white privilege and institutional racism. And the solution is to hire more and more DEI bureaucrats to enhance equity. Now, there's no inherent reason that DEI bureaucrats and bureaucracies should be hostile to Jews and Jewish interests. And some are, in fact, quite welcoming and sympathetic. My daughter is a high school senior. She is being recruited to Washington Lee, and their DEI person is very high on getting more Jews into Washington Lee. But many DEI officers are not interested in accommodating Jews, or much less recruiting them. And some are indeed hostile, because, to put it bluntly, many people who go into DEI are ideologically in the far left. And at best, they see Jews as ordinary privileged whites, and at worst, privileged whites who use their privilege to oppress Palestinians and implicitly to oppress students and faculty of color. So, for example, I look at Rachel Moran and Jennifer Mnuchin, deans at UCLA, Jewish women, say, wow, Jews used to be excluded from elite levels of the legal academy, and now we have 2 Jewish deans, and they're both women, who also were excluded. But so you could see that as a triumph for groups that were excluded. But instead, DEI people will tend to see this, oh, we have 2 more white deans of UCLA. Whites still dominate the deanship. The rise of DEIism has coincided with the rise of critical race theory as a major governing ideology at universities. And this isn't universal to critical race theorists, but one aspect of critical race theory that's relatively common is the argument popularized by Ibram Kendi that if there are any disparities among groups, it's a result of invidious discrimination. So, for example, recently, all 8 Ivy League presidents were Jews. Well, from Kendi's perspective, if all 8 Ivy League presidents were Jews, that doesn't mean great. Jews were overcoming discrimination and their former exclusion from elite universities. Instead, it means that Jews must somehow be collaborating with whites or be themselves whites who are somehow colluding to keep others out, or at least are the implicit beneficiaries of exclusionary systems, and therefore their achievements are undeserved, and rather than being praiseworthy, are unfortunate. Finally, Arab Americans are officially white under federal law as they are classified by federal regulations, but Muslim, especially Arab faculty and students, have been pushing ever more successfully for being considered part of the diversity pool and being recognized as people of color. This wouldn't be so terrible if it was applied consistently, but for example, someone like Linda Sarsour will say, well, I'm a person of color, even though I'm very light complexioned, because I wear a hijab, and that makes me look different. But she wouldn't apply the same standard to a Jewish woman wearing a head covering, or a Hasidic man wearing much more noticeable garb that identifies him as being a member of a minority group. Or to use Sarsour again, Sarsour is very fair-skinned and could, as she acknowledges, pass as an ordinary white girl, would be considered a person of color, whereas a dark-complexioned Iranian Jew would still be considered white. Now, I wouldn't otherwise normally care how Arab Americans are classified as such, but it's being weaponized on college campuses. First of all, they interpret the Israel-Palestinian conflict through this phony racial lens. So Jews are the white oppressors and Palestinians are the people of color, and people of color are always being oppressed by the white people, so the Palestinians must always be right. And moreover, what I've discovered myself in blogging and speaking about this is if you criticize someone like Linda Sarsour or Rashida Tlaib, or on campus, Arab American Muslim activists or anti-Israel, the reaction will be, how dare you, as a white person, criticize a person of color? So this ideological dynamic is directly connected to what I call DEIism, this ideology of the diversity, equity, and inclusion. Again, it doesn't have to be exclusive of Jews, but in practice it often is. And in practice, it just deems Jews to be white people, or maybe even especially privileged white people. And I'm hopeful that a Supreme Court opinion that moves us away from DEI kinds of rationales to whatever follows, including whether we could find political categories like descendants of American slaves, will help dampen this dynamic. Thank you.
Thank you, David. Thank you for leading us through some of the challenges that we face on campuses, including some of the challenges we might anticipate in the wake of such a ruling. We do have a little bit of time for question. I apologize that the time for that was cut short a little bit due to technical difficulties, but please, if you have any questions, please feel free to type them into the chat or do the hand raise emoji.
Hi.
Hi, yes, Scott, go ahead.
First of all, thank you both so much. Incredibly useful and provocative, and just gave me a lot to think about. I just had a brief question, which is, if universities move, if the Supreme Court rules as David, Professor Bernstein was saying, and I think he's right. Do you think that moving to a class-based admissions policy to try to increase diversity or to increase disadvantaged students would be an option? And if so, what do you think the impact will be for Jewish American students?
So I don't know what the latest data is. Back in the 1990s, when California was considering and eventually passed by referendum Proposition 209, this issue came up. Why don't you just use class-based affirmative action? And it turned out the response was that this wouldn't actually lead to the sort of diversity that is official diversity, but would lead to a lot of Chinese immigrant children from working class households who would get that advantage, but don't quite have the SAT scores otherwise of getting in. So I do think that there are, that part of the argument with regard to Harvard was, well, look, Harvard faculty tend to be are disproportionately white, and they're very credentialed, and they tend to get in. Alumni are more likely to be white, but also there are certain sports, like you don't really see all that many black water polo players or lacrosse players, and that you could just stop recruiting for those things. And that, I think those things those tend to be dominated by sort of the traditional Protestant families that have been going to Harvard for generations and would affect Jews less. Universities have gone to their credit, I guess, Stanford, Harvard, other schools like that have actually become much more generous about financial aid. And what you see a lot of schools actually, although mostly on the bottom end, so it not really the bottom, but like people who make less than 125 or 150 or 175 as a family could go for free. People who make over 500 and could afford everything, they don't care. And you wind up with bifurcation. We don't really have the upper middle class as such. Are wealthy and middle class and lower upper middle class and below. That I think does, I mentioned that that diversity slots restrict Jews to some extent, right, just by their nature, but also the fact that universities have expanded to lower income places, that the schools are not as dominated by regional factors, like Harvard used to be mostly Northeastern, not anymore, but also that they're now 15-20% foreign students. It also takes up a lot of slots, and the schools love foreign students because they tend to pay full tuition because they come from wealthy families. So I don't think they're going to go to class-based to replace this, but there has been a movement to make college tuition more affordable for lower income students.
Rachel, do you want to contribute to the answer?
Well, I know we have some other questions, so I'll be very brief. I think that class-based is not going to be a substitute for race. In part, that's because if you look at admissions, affluent Black and Latinx applicants actually get in without affirmative action. And so much of affirmative action is directed at less affluent individuals in those categories, but the most disadvantaged, what sometimes are called the truly disadvantaged, in schools marked by concentrated poverty as well as racial segregation, are not competitive, even with affirmative action. And so when you use socioeconomic status, it primarily, at least based on earlier studies, benefits children of immigrants who are growing up in low income settings, but do very well academically, but maybe just shy of what would be enough to get in without affirmative action. And so you saw that primarily benefiting Latinx, Asian, and white applicants, but not doing a lot for the Black applicants. And so that is an ongoing issue. Other proxies that have been considered are first generation, speaking a language other than English, and one that the court talked about in oral argument, which is your experiences, or your racial experiences versus the box that you check. And would that be okay to consider? So, we'll see how that all plays out, but I don't think it's a substitute. And I also think if you did it to promote racial diversity, the Pacific Legal Foundation might well sue saying that's an illegitimate racial motivation.
So we're at 2, which is technically the end of our webinar, but if David and Rachel can stay on for a little bit longer, I think Professor Trachtenberg has a question.
I do. Am I being heard?
Yes.
It seems to me that the number of schools which are genuinely competitive for admission is pretty modest. Most of the universities in the United States are functionally open admissions. If those schools, that limited number of schools, the Ivy League institutions, MIT or whatever, were to expand their entering class by 14%, 15%, and set that percentage aside for affirmative action, with the balance of the class not having any affirmative action considerations, wouldn't that substantially resolve the controversy?
Well, I think the problem would be the court would see that as a quota. And so they would not permit that kind of approach, because you can't set aside seats. You have to, let every individual compete on his or her own merits. And so I don't think that would be acceptable to the court. I will say, though, I think you make an excellent point. The vast majority of America's colleges and universities are not highly selective.
Yes.
They don't use affirmative action. They effectively have open admissions, but they are often resource poor, and they are struggling to meet the demands of the student body. And so one question is, beyond affirmative action, what else do we need to do to strengthen our system of higher education?
I don't have anything further to add to that.
All right. I think Adam Cohen, do you have a question to ask?
I put it in the chat partly because we're out of time and partly because I was so late. I'm in Arizona where we don't do daylight savings time, and I got that time zone wrong. I was asking about how being Jewish should be treated under the 14th Amendment, if that's relevant and if it hasn't been talked about.
It's funny. It just so happens that we were starting to discuss affirmative action in constitutional law class today, and students were asking me about subgroups. So officially, Jews are, assuming that they are Caucasian and not of one of the minority backgrounds, officially Jews would just be in the white classification. And what would that mean for 14th Amendment purposes if you all argue that there was discrimination against Jews? And you could say that for any ethnic, assuming this is ethnic discrimination, any ethnic subgroup. What if the government has a policy that hurts Italians but helps Polish people? Could the Italians sue? And oddly enough, this is, to my knowledge, at least, I was trying to say that to think about this on the fly. This is much more unsettled in the law than you would think it would be. Exactly. Would that be national origin discrimination? Is it ethnic? There is precedent to the extent that Jews were considered a race in 1866. Therefore, the 1866 Civil Rights Act counts them as a race. That hasn't been applied directly by the Supreme Court in the 14th Amendment context. There's also the separate issue. This is an issue that's come up a lot with discrimination against Jews on campus. For a long time, Jews were not considered to be covered by the 1964 Civil Rights Act because it doesn't prohibit religious discrimination in order to allow religious schools to continue to function. But Ken Marcus, when he was at the Bush II Department of Education, persuaded the department to issue regulations that says, but Jews are both an ethnic group and a religious group. If they're discriminated against on a religious basis, that is not covered by Title VI. But if they're discriminated against on an ethnic basis, that's something like national origin discrimination and is covered by the laws. And that is the Obama administration, the Trump administration both reiterated that policy. So to make a long story short, it's actually a very complicated question, exactly how that's treated.
Yeah, I mean, the reason I'm asking is because this is the sort of thing I do research on from a psychology perspective, like the overlap between ethnicity and religion. And anytime I've talked to a law colleague about this question, they've said, oh, no, you don't have to worry about this because of the First Amendment. And I say, no, there's equal protection questions and suspect classification questions. And this is a paper I want to write. So if you'd ever want to think about that, I'd love to be in touch.
Okay, great.
The only
Great, we
thing
love
that I would add is if you treat this as a suspect classification, you do run into the problem that you can't use that classification for government legislation when you might want to for First Amendment reasons. For example, there's religious exemptions, right? For like, you know, I need to observe the Sabbath, I should be exempted from certain laws, or I don't have to pay taxes because I'm a synagogue, right? Or I, you know, I want to marry within my faith, and I'm not going to pick, I'm not going to go to clubs that don't include other people like me. Some, you know, there's all kinds of private decisions you make that relate to your free exercise of religion or relate to the separation of church and state. And when you have a suspect classification like race, it doesn't give you much flexibility as a government actor to use that classification. And clearly government needs that flexibility because this is also related to religious exercise and the Establishment Clause.
Okay, so I think that does it for our webinar today. Thank you all for participating. Thank you especially to Rachel and David for sharing their analysis and insights. This is, you know, we were expecting a ruling in June, and there will be things to grapple with for academics, for organizations, for campuses. So thank you all very much.
Thank you.